Whether a builder can stop work for non-payment in Queensland is a common question, but the answer depends not just on whether payment has been withheld, but whether there is a clear legal right to suspend work. Under Queensland law, a builder cannot simply stop work because they've not been paid. The right to suspend work must arise either from the construction contract itself or from statutory rights under the Building Industry Fairness Security of Payments Act 2017. Simply being unpaid is not enough. The builder must be legally entitled to respond by suspending performance. In many cases, construction contracts include express suspension clauses that allow a builder to stop work if payment is overdue. These clauses usually set out strict requirements, including issuing written notices, allowing time for the breach to be remedied, and complying with specific procedural steps. Failing to follow these requirements can invalidate the suspension and expose the builder to risk. In addition to contractual rights, the Security of Payments legislation provides a statutory right to suspend work in certain circumstances. This typically requires the builder to have issued a valid payment claim, for payment to be overdue, and for written notice of intention to suspend be given, with at least 2 business days before work is stopped. However, the risks of getting this wrong are significant. If the builder suspends work without valid legal basis, the suspension may itself amount to a breach of the contract or repudiation, potentially allowing the principal to terminate the contract and claim damages. In many cases, those damages can far exceed the amount of the unpaid invoice, making wrongful suspension a high-risk decision. There are also practical complications where payment is disputed, particularly made or subject to set-off claims. In these situations, determining whether there has been non-payment in a legal sense can be complex and highly fact-dependent. Because the right to stop work is governed by strict contractual and statutory requirements, careful analysis is required before taking action. Understanding whether the preconditions have been satisfied, what notices are required, and what risks arise from suspension is critical to protecting your legal commercial position. Contact us today for a free 30-minute consultation with one of our experienced team of building and construction professionals, and let us help you protect your rights.